inflammatory evidence that the defense is seeking to have withheld or not shown to the jury. This document's interesting, folks, because we don't know what it is. On February 24, 2025, the defendant's motion in limine responds to inflammatory evidence. Okay, so the state's responding to this document. And it states, quote, unfortunately, the defendant does not specify what potential evidence he is objecting to as exceptionally inflammatory, nor does the defendant define exceptionally inflammatory. It continues, that said, this is an appropriate opportunity to review the applicable standards. In the second paragraph on page 2 of the defendant's instant motion, he lists 3 cases purportedly relating to inflammatory evidence, including testimony evidence. Yes, folks, that's the other one. Testimony can be inflammatory if it's incorrect or if it's a lie. It continues, however, on review, these cases seem to pertain to allegations of prosecutorial misconduct in closing argument intended to inflame the jury. Well, that's all that's happened this whole case. The state respectfully submits that when it comes to allegedly inflammatory evidence, the proper analysis is under State versus Levitt. In Levitt, the Idaho Supreme Court addressed color photographs of a victim's corpse being admitted into evidence. Yes, folks. The document concludes the state requests that the court deny the defendant's instant motion with the understanding that the applicable legal standards are outlined above, and it is incumbent on the defendant to specify what actual evidence he believes the court should prohibit. And there must be a reason why they don't want to tell prosecutors, because they know they'll do something probably to bury it, because that's all they've been doing. And there's a reason why the defense does not trust prosecutors, and I don't either, and you shouldn't either. The defense wrote in their document, quote, they moved the court for an order preventing the prosecution from introducing irrelevant and unfairly prejudicial photographs, testimony, and other exhibits in violation of his rights to a fair trial, protected through the 5th, 6th, 14th Amendments of the U.S. Constitution and also the Idaho Constitution. And Mr. Koberger respectfully requests this court order the state to not try the case through eliciting testimony and other evidence that is exceptionally inflammatory. So that could be the roommate's testimony. I think the most interesting portion of this document is where it states, quote, multiple studies have found that mock jurors are more likely to convict when exposed to graphic photos. Yes. And so that makes you wonder, would that be of the crime scene itself? Would that be the bodies? Would that be testimony that goes with photographs? I mean, I don't know. We do know prosecutors are all about smoke and mirrors, and that's what the whole case has been about. So would I be shocked if prosecutors used inflammatory evidence to try to sell their case because they don't have real evidence, and to use that to distract the jury from realizing, wait a minute, you don't have any actual definitive evidence. You're all speculation, opinions, theories, and hunches. But where's the real evidence? I can see prosecutors doing that to try to get around some of these large gaps of evidence holes that are in their case.